Okay, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, I will let you know if I've determined probable cause, and then we will talk about release conditions. Today's not your trial date. Today's just the day that you get to hear what you are being charged with or being faced with being charged with. And so I advise you not to talk about your case on the record because everything in this courtroom is being recorded. You do have attorneys that are assigned to some of you from the Public Defender's Office, and in the courtroom, I have Attorney Brian Reedy, and over at the main jail, you have Attorney Hector Romero. For those of you represented by the Public Defender's Office, you may want to speak with those attorneys before you say anything on the record so that they can advise you. For those of you who have private counsel, they usually come to the courtroom and they'll be here to be able to speak on your behalf. If you have private counsel and they are not in the courtroom, you can let me know and we will see how we can accommodate that process. But I also want to let you know that just because you've used an attorney 10 years ago and today you're before the court, doesn't necessarily mean that they are still your attorney. So please don't tell us that you have private counsel if you have not retained them for this current arrest. We waste time trying to call attorneys and then they tell us that they're not representing you on this case. So please bear that in mind. We also have in the courtroom the attorneys from the state attorney's office, and they're here and they can provide us with information on prior records, and stuff like that, as well as we have confinement status, we have pretrial supervision services, and the clerk of court. So we've got a full stacked courtroom. Information is available to the judge so that I can make a better determination as to setting your release conditions. But all those will be addressed as you come up, all right? I've read all the police reports. I've made a determination, but as I said, if you have your attorney, arguments can be made, and I'll hear from either party, all right? So this morning, I know this is a reset from yesterday, Angela Bloodworth,
North Broward, Judge.
she in?
No, she's about morning.
Yesterday, we were waiting for her to be transported, and now this morning, she's a medical reset. All right, we'll see Ms. Bloodworth shortly then,
This is Mr. Sheets' first one. It's first on the docket.
when you have all of them.
Okay.
Committee of the top part.
This is not as important as her signature.
All right, Rachel Rooney. Good morning, Ms. Rooney. You are before the court for a traffic capias matter. It's a charge of operating without a valid driver's license. And the court does find probable cause. What does Ms. Rooney wish to do?
Judge, she wishes to resolve this matter today.
Magistrate court, here we got a fellow by the name of.
All right, does the state have an offer for Ms. Rooney?
Yes, one moment, Judge. Restraining order. No problem.
Offer be withholding court costs, Judge.
Okay.
Judge, she wishes to accept the state's offer.
All right, Ms. Rooney, do you understand the offer that has been presented to you?
Yep,
And you wish to accept that offer?
yes,
Okay, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Covered by sudden snap.
yes,
Okay, you can put your hand down. Ms. Rooney, is anyone forcing you to resolve your case?
no,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no,
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
yes,
Have you ever been treated for mental or emotional illness?
no,
And do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
yes.
What plea do you wish to enter, ma'am?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and your sentences of withhold adjudication and court costs. Good luck. All right, Lynina Rosario.
She's approaching, Judge. She's here at Maine.
Ms. Rosario, you're before the court. It's one count of knowingly giving false name to law enforcement, and the court does find probable cause. Does anyone wish to be heard as to the bond? Oh,
Judge, I do. My understanding is Ms. Rosario advised me she has a clean record. She's been here her whole entire life, born and raised. Right now, she is not working, but she lives in Oakland Park. She's going through a hard financial time. She may be evicted soon, Judge. I did advise her, though, she did tell me she's coming back to court, and she will, if she changes her address, update it with the clerk's office to make sure she knows when to come back to court. Judge, considering if she has a clean record, I'm going to ask for the court to consider releasing her under her own recognizance.
I don't have an objection to non-monetary release, Your Honor.
okay. All right, Ms. Rosario, the court will release you on your own recognizance. You need to make sure that if you change your address, you let the clerks know so that you don't miss court, okay?
All right.
Someone she knows who
All right, on page 1, Alicia Armidio, Mr. Shade.
North Row.
All right, ma'am, you are before the court for municipal ordinance violation on a possession of drug paraphernalia charge.
The city would offer a time served.
Ms. Armidio, what do you wish to do? Do you wish to resolve the case today?
Yes, please. I don't have anybody to postpone.
All right, what did you say the offer was, Mr.
It'd be
Shea?
time served, Judge.
All right,
I didn't understand.
all right, it's a city violation, and so the city is offering adjudication and time served to resolve the case.
Okay.
All right, so if you wish to accept that, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down, ma'am. And Ms. Armidio, you understand everything that's going on here today?
Yes.
Is
I'll be
any-
released today?
Yes. Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with the attorney?
No.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that would affect you making a decision?
No.
All right, and do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right, what plea do you wish to enter, ma'am?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck.
Thank you.
All right, on page 8, Antonio Hawkins. All right, Mr. Hawkins, good morning, sir. You are before the court for a misdemeanor, a municipal, a city ordinance violation, and the court does find probable cause.
This is actually a case out of the city of Hollywood. They would offer time served.
All right. Mr. Hawkins, the city of Hollywood is offering adjudication and time served to resolve the case. Do you wish to do that, sir?
Yes,
All right, sir, as best you can, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. Mr. Hawkins, you understand everything that's going on here today?
Yes.
Are you under the influence of drugs or alcohol?
No.
Is anyone forcing you to resolve your case?
No.
Do you need any more time to speak with the attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Hawkins?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir. Richard Crump, on page 8.
Mr. Cross, come on up.
All right, Mr. Crump, you're also before the court for a city ordinance violation. And the court does find probable cause. Mr. Crump, what do you wish to do today?
I resolve the case.
All right, what's the offer?
Time served.
All right, Mr. Crump, the offer is adjudication and time served. Do you wish to accept that offer?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Crump, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes, ma'am. I understand.
And have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you're not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes?
Yes, ma'am. I understand.
What plea do you wish to enter, Mr. Crump?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. Good luck.
Okay, thank you.
Do we have William Ellerby on page 14 in the room?
Yes.
All right,
Judge, I believe Mr. Ellerby also has felony matters.
yes,
He's approaching, Joe.
okay.
Ellerby?
What are the charges?
He's
William Ellerby
got
on
possession.
page 14. All right, Mr. Ellerby, you are before the court. Count 1 is robbery with a firearm, and then count 2 is a misdemeanor capious matter. It's a city ordinance violation. So the court does find probable cause. He does have court tomorrow on the capious matter. And I'll hear from the parties as to bond.
Judge, as for the city case, we just asked that it go to the division tomorrow.
Okay?
He's technically not a victim because if you see him.
Ellerby, page 14.
I apologize, Your Honor. Okay. You can ask me questions. Scott, Michelle, I think you've got Ellerby. Your Honor, I'm going to be seeking a finding of proof evident or presumption great and a no bond hold for first appearance purposes, noting that the incident was captured on video surveillance. Mr. Ellerby's fingerprints were found on the tip jar, which the suspect that was captured on surveillance is seen touching the same tip jar. The officer notes that Mr. Ellerby's height and build and weight match the description of this the suspect that was caught on surveillance touching the tip jar. Also noting that Mr. Ellerby's cell phone data indicates that he was within a close distance to this Subway restaurant where the robbery occurred on the date and time when the robbery occurred.
And we would object to the court making a finding of proof evident presumption grade at this stage of the proceedings. The state has not introduced this video, so we can see for ourselves whether or not the robber is of the same height and build as Mr. Ellerby. They have introduced no fingerprint comparisons. In fact, nobody was able to identify Mr. Ellerby by face. The only evidence connecting him to this crime is evidence that the state has failed to produce before this court this morning. Proof evident presumption grade is the highest standard of proof that we have in our criminal justice system, and based on what the state has produced or failed to produce here this morning, we would submit to the court that that very high standard has not been met. If over our objection the court finds that proof evident presumption grade has been established, then we would ask the court to exercise its discretion and set bond for Mr. Ellerby.
Okay.
Your Honor, Ms. Ellaby is currently on pretrial supervision in case number 180057444 CF10A, ag fleeing and eluded law enforcement officer. He was released from custody December 14th, 2018 on a $1,000 bond along with pretrial release supervision. At this time, we're requesting a revocation of his supervision.
Your Honor, that's an additional reason why, if the court finds proof evident or presumption great that the state believes a no bond hold is appropriate on the new charge.
All right. I've received the probable cause affidavit, and based on the information provided therein, there's fingerprint evidence, there's video, there's surveillance. The court does find probable cause, and further will make a preliminary finding of proof evident presumption great and hold Mr. Ellerby no bond on this new arrest. This proof evident presumption grade is without prejudice for the defendant to file a motion to set bond based on State v. Arthur. As to case number 18-005744 CF10A, Mr. Ellerby was placed on pretrial supervision on the charge of aggravated fleeing and eluding, and the court pretrial has asked that the pretrial services be revoked, and the court will grant that motion and hold Mr. Ellerby no bond until further order of the court. All right. Courtney Chapman.
She's approaching, Judge. She's here, ma'am.
All right, Ms. Chapman is before the court for grand theft, and count 2 is dealing in stolen property. The court does find probable cause.
Judge, at this time, I'm going to ask the court to consider releasing Ms. Chapman on pretrial release on these nonviolent offenses. According to Ms. Chapman, right now she's not in a financial position to post a monetary bond, nor anyone else on her behalf. She's 36 years old, been living in our community now for about 13 years. She is working part-time in a security company for months now. She managed to get that job, and right now she's hoping to turn around her bad financial situation. She's right now making approximately $12 an hour, and she's working 4 days a week and trying to pick up as many shifts as possible. Right now she is homeless, Judge. Unfortunately, she's been homeless now for about 3 weeks, and now that's part of a financial crisis. Judge, like I said, there's no one to post her monetary bond, so that is why we're asking for the court to consider releasing her on pretrial release.
Your Honor, the state opposes pretrial because she was arrested January this year on capiases for failing to appear in court. The last time she was put in pretrial, and that was a 2017 prostitution case, she was taken into custody on a warrant for violating her pretrial, and the violation was based on she failed to submit to random drug and alcohol testing, and she failed to call pretrial 2 times a week. A moment. Your Honor, based on that, and the information Mr. Romero is providing, I don't believe she's a good candidate for pretrial.
Judge, I do understand, but, and speaking to Ms. Chapman, I'm certainly, the state's gonna verify this. My understanding, this is, those prior incidents, those were misdemeanor offenses. My understanding, she has no prior, felony convictions. She is facing felony charges now. I did stress the importance of coming to court. She did assure me she will be coming back to court to face these allegations, Judge. But right now, financially, she just can't post bond, so that's why she's asking to be supervised this time. She doesn't want to risk losing her job, Judge. Right now, she's trying to get out of the hole that she's in, Judge.
Well, she needs an address, as I'm not gonna ROR her, so if she's gonna be placed on pretrial supervision, she needs an address.
Standard pretrial, she doesn't need an address. For level 2 with monitor, she does, Judge. I did advise her. Right now, she is working, and she's trying to save up to find a place. As soon as she gets a residence, she's going to go ahead and basically provide that clerk's office. I can find out right now if she has any family member that she could use as a mailing address, Judge.
Well, based on her prior failures to appear, I am not, it's gonna be a level 2, so it's either that she's gonna post the bond or she's gonna be placed on level 2 GPS.
Judge. Won't be out here.
Where's it going to be?
Doesn't have to be in West Palm.
Well, West Palm Beach is fine. Okay. Judge, I apologize. She did advise me she can find a place. It's not going to be in Broward County, but it's going to be in Palm Beach. I did advise her. Pretrial will be verifying
She can talk
this.
to the people and all.
They're going to be verifying. So if they can verify, then yes, she says she would accept level 2.
Okay,
Thank you, Judge.
all right, the Spanish interpreter is here. Who needs a Spanish interpreter?
There's 2 gentlemen at the main jail, Your Honor.
What are their names?
Pages 10, Judge. The first person is Mr. Benicio Tellez, who is on page 7, and the other gentleman is on page 10, and his name is Mr. Faustino Alachan. Senor Tellez.
On which one? No, it's ROR to pretrial, level 2, thanks, yeah. All right, Benicio Tellez,
Señor Benicio Tellez,
sir, you are before the court this morning.
está usted acá ante la corte hoy en la mañana
Count 1,
en el primer cargo,
contributing to delinquency of a child.
contribuir con la cometer un delito, que un niño cometiera un delito.
Count 2 is DUI, alcohol or drugs, first offense.
El segundo es manejar bajo la influencia de alcohol o drogas, primera vez que le acusan de esa ofensa.
And count 3 is breath alcohol of greater than 0.15.
Y el tercer cargo es que el nivel de alcohol en la sangre estaba más arriba de 0.15.
Okay, the court does find probable cause.
La corte encuentra que hay causa probable para el delito.
And I'll hear from the attorneys as to bond.
I'm sorry, Your Honor.
I'll hear from the attorneys as to bond.
Para ponerle la fianza, primero voy a escuchar lo que tiene que decir su abogado.
Judge, in speaking Mr. Tellez, my understanding, this is his first time being arrested in his life.
Yo lo que entiendo, dice su abogado, es que el señor Tellez es la primera vez que lo arrestan en su vida.
He's been here for over 10 years.
Ha estado acá viviendo por más de 10 años.
Judge, Joe, Judge, even though he has a clean record at this time, it's Mr. Tellez, he's going to be requesting a phone order. He thinks he can contact friends and family.
El señor Telles está solicitando que le pasen su teléfono celular para que pueda contactarse con familiares o amistades. Para la fianza.
Okay. Does the state wish to be heard on Mr. Tellez?
¿Quieren escuchar al señor fiscal sobre lo que tiene que decir sobre su caso, señor Telles?
Your Honor, in addition to the bond,
Además de la fianza, yo estoy solicitando
I'm going to be requesting pretrial supervision
supervisión con el programa pre-trial, supervisión anterior al juicio,
no alcohol or intoxicants,
orden de no consumir ni alcohol ni intoxicantes
and random testing.
y que le hagan a usted exámenes de drogas o de alcohol sin avisarle.
I'm concerned about the level of intoxication in this case.
Estoy preocupado, dice el señor fiscal, del nivel de intoxicación de alcohol o drogas en la sangre.
He had a minor as a passenger in his vehicle,
Tenía usted un vehículo
and he pulled up to a guard gate of a community,
y usted parqueó por delante de la reja de una comunidad privada.
and began to place a food order.
I'm sorry.
Began to place a food order,
Y empezó usted a ordenar una comida
since it appears he believed he was at a fast food restaurant.
y aparentemente usted creía que estaba usted frente a un restaurante.
Judge, I have no objection as far as if the court wanted to order no alcohol or
No me
intoxicants.
opongo a que la corte ponga una orden de que usted no consuma alcohol,
But considering this is his first time with the criminal justice system, I
pero
think it's
considerando de
just
que esta es la
impose
primera
standard law.
vez que usted se enfrenta al sistema judicial. Sorry, interpreter didn't hear the last part.
Excuse me?
She
Considering
didn't
that
hear everything you said.
Oh, we're just asking for the standard bond to be kept in place.
estamos solamente pidiendo que le den a usted la fianza estándar, en este caso.
All right, in reviewing this probable cause affidavit,
Estoy revisando el affidavit de causa probable.
the court does have cause for concern for the community.
La Corte tiene preocupaciones por la comunidad.
In addition to what was said before,
Además de lo que se indicó antes,
Mr. Tellez did also provide samples .162 and .180.
También usted proporcionó muestras de sangre de 1.62 y .60.
In addition to the minor that was in the car with him,
Aparte de la situación que usted tenía un menor de edad en el carro con usted,
and it's also believed that she was also under the influence of alcohol.
me da la impresión de que ella también estaba bajo la influencia del alcohol.
As such, the court believes that a reasonable release conditions
Entonces la Corte opina de que una condición para darle la libertad razonablemente
will include the bond plus
sería,
pretrial supervision.
sería ponerle la fianza más supervisión del programa pre-trial, supervisión anterior al juicio,
There'll be a TAD monitor,
con un monitor satelital,
no intoxicants.
orden de no consumir alcohol ni intoxicantes.
Okay. GPS, no, standard with the TAD.
Monitor estándar.
Okay. All right, thank you.
Gracias.
And then Faustino Alarcon.
Eh,
He's approaching.
I don't have his
All right, sir, Mr. Alarcon, you're before the court.
Señor Alarcón, usted está hoy enfrente de la corte
There's 2 traffic capias matters,
por 2 asuntos de tránsito.
operating without a valid license
Manejar sin licencia válida
and having a suspended driver's license.
y tener una licencia suspendida.
All right, the court does find probable cause.
La corte encuentra que hay causa probable para el delito.
And what does Mr. Alarcon wish to do?
¿Qué es lo que usted que quiere hacer?
Nothing to add at this time, Judge.
All right. So the bonds are $250 and $1,000.
Las fianzas van a ser $250 para un cargo y $1,000 para el segundo cargo.
Good luck, sir.
Que tenga buena suerte.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite la intérprete?
Not here at Main, Judge.
At any of the other facilities, do we need a Spanish interpreter?
Not at Conti, Your Honor.
Okay,
No, bro, we're good.
all right. Thank you.
You're welcome.
All right. Okay, on page 15, we have someone signed in for Antonio Hill.
Yes, Judge.
Is Mr. Hill in the room?
He's not here in the room,
All right,
Judge.
then we
Is it a private attorney or?
No, the state attorney's here on that
Oh.
case.
Sorry. We'll bring him in.
All right. As soon as he's in, let us know.
I'll need to talk to him, Judge.
All right, and then and then Vincent Davila, who's on page 14. They have to bring him in, Mr. Hecker.
He's not here yet, but
They-
they're gonna be bringing him, Judge.
Okay,
And he has Mr. Hecker?
yes. With the new rules, the jail does not bring all the persons in, so depending on where they are on the docket, we have to let them know so they can bring him in. So as soon as they bring him in, we can address your case.
Sounds good, Judge. If I'm missing in the interim, I'm in front of Judge Malek.
No problem.
Thank you, Judge.
No problem. All right. Okay, Emily Martinez,
She's before Judge Duffy this morning, Your Honor.
okay, Ms. Martinez is in court. Keith McPartland,
Mr. McCartland is approaching, Judge. He's here at Main. And, Mr. McPartland declined the services of public defender. Mr. Hill, come on over.
all right, good morning, sir. You are before the court. Count 1 is a touch or strike battery, domestic. And count 2 is felony violation of probation, which does have a no bond hold. And you will be before your division judge tomorrow at 8:30. The court does find probable cause as to the touch or strike battery. And I'm going to impose a bond on that count of $2,500. Okay?
Okay.
All right, good luck, sir.
Your Honor, I'd
Thank
ask
you.
for an order, no.
And no victim contact. Filberto Pena,
Judge, he's approaching. He's here at Main.
okay? All right, Mr. Pena, you are before the court. Count 1 is false imprisonment, and count 2 is touch or strike battery domestic. The court does find probable cause, and we'll hear from the parties.
Your Honor, I'm requesting a $10,000 bond on count 1, $5,000 bond on count 2. This is based on the level of violence alleged, the physical injuries suffered by the victim. I would also note that it appears that this incident in its entirety occurred while the couple's children were present in the home, the former couple. That's fine. I'll just-
Yes,
Judge, I'm going to be requesting on Mr. Pena's behalf a $5,000 bond on count 1 and a $1,000 bond on the misdemeanor count 2. My understanding, Judge, this is his first contact with the criminal justice system. He is a registered voter here in Broward County. He's 36 years old, been living in our community since 2003. He is currently employed. He works at a company called Urel Auto Solutions, where he's been employed there since November. Now, he does not live with the alleged victim. He lives in Plantation by himself, in which he pays approximately $1,300. My understanding is he has family that lives in our community. He actually gave me phone numbers of his sister and his mother, who I intend on contacting after court to help post his monetary bond. Considering Judge his lack of criminal priors, that is why I'm asking for $5,000 on one and $1,000 on two.
Okay, Mr. Pena, the court is ordering no victim contact until further order of the court. That means no phone calls, no emails, no social media, no third party getting in touch with her until an order comes from the court saying you can have contact. The court is also going to impose on count one, a $5,000 bond, and then on count two, $2,000 bond. Right? All right, Michael Zarcone.
Mr. Zarcone is here at Maine. Come on up, sir.
Mr. Zarcone, you are before the court. Counts 1, 2, and 3 are uttering false instrument. Count 4 is grand theft. Count 5 is a misdemeanor capious matter for a battery. That has a no bond hold, and you will be before your misdemeanor court tomorrow at 9 a.m. The court does find probable cause as to all the other counts. Does the parties wish to be heard?
Judge, my understanding is, speaking to Mr. Zarcone, is he actually surrendered himself on this. I see, and I did advise him count 5. There's nothing this court can do. He's going to be seeing his judge tomorrow. He believes that potentially tomorrow he will be given some sort of bond. Right now, he has very limited funds. He's 27 years old. He's currently working. He only makes about $100 a day. He has enough to bond out on counts 1 and 2. So what we're requesting, Judge, considering he did surrender himself, is just on counts 3 and 4, if the court will consider an ROR, so that if he is released tomorrow, given a bond, he could be in a position to post his bond.
Your Honor, I'd ask that the court keep the bonds in place. Mr. Zarcone has a no bond hold because he failed to appear at a change of plea before Judge McHugh. On that same case, he was arrested March 5th of this year for failing to appear in court. It shows the arrest location was the Fort Lauderdale Police Department, so he turned himself in then. That didn't prevent him from then failing to appear in court on April 26th. So I don't see how Mr. O'Mara's argument really should really motivate the court. I'd also note that it appears that these offenses occurred while he had a pending misdemeanor, so that's another cause for concern. I really don't see any basis to mitigate on the bond amounts.
Judge, the basis is he turned himself in, from what Mr. Zlender said, on 2 separate occasions. And on this occasion, the reason why he missed, he thought he had a waiver of prosecution. A waiver of appearance. So therefore, Judge, that's why he surrendered himself. That's why he believes tomorrow that the judge will go ahead and either reinstate him or release him. So that is why we're asking on counts 3 and 4 in ROR.
All right, the court does find probable cause. The standard bonds on 1 through 4 will remain. And as I said before, he does have court with his misdemeanor judge tomorrow. All right. On page 4, there's a Hewart Bailey.
Mr. Hewart Bailey, Judge?
Yes.
He's here. Judge, my understanding...
No, we're done. He just had a question.
Oh, Judge, my understanding is he hired private counsel. Come on over. And I believe my colleague contacted his sister to get the name of the private attorney that they hired. And I believe Mr. Reedy's been trying to get in touch with them.
Yes, Judge, I spoke with Mr. Lyon Greenblatt. He anticipates being retained. He has not been retained as of yet. He's asking the court to set bond, and he will file a bond motion in front of the division judge.
All right. So, Mr. Bailey, you are before the court for count one is a robbery by sudden snatching without a firearm. Count two is burglary, unoccupied conveyance unarmed. Count three is grand theft. And count four is a violation of injunction protection, domestic violence. And the court does find probable cause as to all those counts.
Your Honor, I'm going to be requesting a bond in the following amounts: $10,000 on count one, $5,000 on count two, $1,000 on count three, and $10,000 on count four. No victim contact, pretrial release with a GPS monitor level 2. Your Honor, I can advise the court, this is a filed case, and I looked through the supplemental reports, and it's noted the officer that wrote the report also took a sworn statement from the victim's adult daughter who witnessed the incident and corroborated her version of events. It was a sworn statement. It was also taken, I believe, by body-worn camera. I would note, I reviewed the victim's petition for the injunction, the permanent injunction that was granted. It notes that the two parties have been in a relationship on and off over a period of years. She alleges that Mr. Bailey has broken the windows of her home. He has broken into her garage. On occasions, he has called hundreds of times over the period of several hours. He's parked near her home all night. And this petition was obviously prepared before this alleged incident because it has the charge of violation of an injunction. In her petition, she notes essentially the same exact incident occurred in October of last year at her home. When she came home, as soon as she got out of her car, Mr. Bailey confronted her, tried to grab her car keys out of her hand, take from her physical possession. Your Honor, the victim notes in her petition that she is in fear of Mr. Bailey. She feels like he will hurt her or possibly kill her. She is unsure of what he is capable of.
Okay. James?
Morning, Your Honor. I'm here on behalf of the sister, Anne-Marie.
Okay.
I spoke to him regarding bond amount. They're probably capable of doing a bond of half that amount, which is about $16,000, 10% of $1,600. So we just request that you do $5,000 on one, $1,000, and $5,000 on the last count. So.
The court does find probable cause, and the allegations are concerning to the court and to the safety of the community. There's an injunction in place that says stay away. So, the court imposing another stay away order. I hope that it'll make a difference. Because if there's a court order that says stay away, you stay away. So the court finding probable cause on count one, I am going to impose a $10,000 bond. On count two, $5,000. On count one, $1,000. On count four, three is $1,000, and count four is $30,000, and that's going to be with a level 1 GPS. And again, no victim contact.
Thank you. Yeah, I'm gonna let him.
Miss, Judge, can I speak a minute if you mind?
Okay.
Yes, I just opened my business and I was supposed to open it Friday. Is there any way I could go to my business to open my business, please?
I have no control over that, sir.
No, but you said I can't. You can't want me. I can't leave my house. You said.
Right.
Huh?
Right. You're going to be on a level 1 GPS.
So.
Sir, I'm not making any changes. I've already made my ruling, okay? Elijah Harris.
But how am I going to work?
We have
I
Elijah,
apologize, Judge, who did you call?
Elijah Harris.
Oh, Elijah Harris. Mr. Harris?
Mr. Harris, you are before the court on a misdemeanor capious matter. It's resisting without violence. Looks like it's a summons from April 15th. So what does Mr. Harris wish to do?
Judge, and speaking Mr. Harris, he wishes to ask whether the court would consider resolving this case today for time served.
All right.
One moment, Your Honor.
And please let me know if, when Antonio Hill and Vincent Davila are ready.
Mr. Hill is here present. We're ready to proceed on Mr. Hill. And
Okay.
Mr. Davila is here. And Mr. Davila is here present, Judge. I've been informed.
Okay, all right.
Your Honor, the state's offer would involve some jail time, and I only mention that because I know Mr. Romero is requesting a time served. If he wants me to continue with the offer, I will.
How many days?
Be 10.
Let me talk.
Just so the court's aware of the reason for this offer, he fled from law enforcement while they were trying to arrest him on a felony warrant, and that's on an open felony battery due to priors. He's been to state prison on 2 separate burglary of dwellings where he was qualified as a habitual offender, multiple years in state prison.
Judge, at this time, Mr. Harris declines the state's offer.
Okay, all right. All right, I believe this is they're saying that there's also been 5 bond surrenders. I believe this is a situation where Mr. Harris may want to wait to consult with his attorneys further, okay? All right, so if we can address Antonio Hill on page 15.
Thank you. Good morning, Judge Veronica.
Who do you want to do, Judge, Mr. Hill or Mr.
Hill, well,
or Mr. Davila?
well, Mr. Hill is standing before us, right?
Okay.
So we'll
Yeah.
handle Mr. Hill.
No problem, Judge. Yes,
All
ma'am.
right. All right, Mr. Hill, you are before the court. Count 1 is vehicular homicide, and count 2 is reckless driving, damage to personal property. And the court does find probable cause.
Thank you, Judge. As far as a bond, the state is seeking $100,000 fully collateralized with no driving, no drugs or alcohol, random testing, and level 1 pretrial release to surrender any passport if Mr. Hill does have one and not to apply for one during the case. Mr. Hill, as the court was able to read, was driving on this day his brand new 2018, new at the time, Chevy Camaro at twice the speed limit in a 35 mile per hour residential area. Mr. Hill also did have alcohol in his system. Over 4 hours after the crash, came back at a .07. This crash where he T-boned the victim who was crossing the street lawfully. The victim's vehicle was T-boned and resulted in the death of Mr. McClover. As far as his history, the defendant does have a prior careless driving in 2015 in West Palm Beach, where there was a crash involved. He was adjudicated on that. He has a prior 2011 burglary, dwelling unoccupied, and grand theft. And he has a prior 2011 failure to yield right away in a left turn that was adjudicated. He does also have some other driving while license suspended charges, but most significantly, the court should know that the defendant does have a current DUI misdemeanor case from March of this year where he was found passed out behind the wheel at a Wendy's drive-through for about 30 minutes. So the state is seeking the bond that I have already outlined.
Okay.
Judge, We're not in agreement as far as the state's recommendation as far as a level one. We're gonna be asking the court to consider, standard pretrial release on Mr. Hill's behalf. Also, Judge, he does not have a US passport. He hasn't applied for one, so there's no passport to surrender. As far as the monetary bond, $100,000 is something financially out of reach for Mr. Hill or his family. Judge, he's been here his whole entire life. He's 34 years old. He's not a convicted felon. He's a U.S. citizen, and he's a registered voter here in Broward County. He lives locally here with his wife and 4 kids. All his 4 kids go to public school, and his wife works for the Broward County School Board in the cafeteria. And speaking to him last year in his taxes, he made about $25,000 for the whole entire year, and his wife made about $20,000, and that was used to support his whole entire family. So just financially, they can't come up with what the state is suggesting. I'm asking the court to consider a $25,000 bond on count 1 with standard pre. What's important from my conversation with Mr. Hill, Judge, is my understanding is that this took place in May of last year. Since then, he's having conversations with the Lauderhill Police Department. He actually had a conversation with Detective Rogers. My understanding is he knew this was coming. In that phone conversation, they addressed where they could meet. The detective over the phone told them that they're meeting to take him to custody. So he went and met with the detective knowing he was going to be in custody. Judge, if this is a person that wanted to flee, certainly he wouldn't have been there at that meeting. He knew this was going on. He wouldn't try to follow up with the police department. I think what the state is suggesting as far as a level 1 bond surrender, Judge, I do not think it's reasonable considering the circumstances. So that's why I'm asking at this time for standard pretrial release with $25,000 bond on count 1.
All right.
Judge, if I may briefly respond.
Yes.
While the crash did take place in May of last year, as the court knows, these cases take a long time to investigate. I do know that the defendant was in fact interviewed by the police actually at the hospital at the crash, so I'm not certain what defense counsel is discussing about meeting with any detective afterwards, and I don't have a Detective Rogers on my case, so I don't know if there's some confusion with that. And perhaps discussing another matter. Additionally, while what the defendant can afford is a factor to consider, there are a number of factors, obviously, as the court knows, and the state is very concerned with the danger to the community, given that there was a death involved in this case, and the same driving with alcohol has continued clearly with another case.
Judge, I was just trying to make Mr. Hill thought he had the actual business card with the detective he met. He doesn't have it it's in his property. So Judge, he actually met with the detective.
When they came to the hospital.
Judge, he actually met with the detective and surrendered himself.
All right. Based on the allegations before the court, I am going to, on count 1, impose a $100,000 bond. It is going to be a level 2 pretrial. And Mr. Hill State has indicated that he does not have a passport, so. He just cannot apply for one during the pendency of this case, okay?
Yes, sir.
All right.
And Judge, is that fully collateralized
Yes.
for the bond?
Yes.
And is there any driving or drugs and alcohol?
No right.
So no driving and no drugs or alcohol?
No driving, no drugs, no alcohol.
With the random testing?
Yes.
Okay, thank you.
Okay, all right, and then Mr. Hicker. Vincent Davila on page 14.
Sir, come on up. Your attorney's right there present, okay?
Mr. Hicker. Good morning. All
Scott
right.
Hecker on behalf of Mr. Davila.
All right, Mr. Davila, you are before the court for aggravated assault with a deadly weapon without intent to kill. Mr. Hicker, have you had an opportunity to speak with the state? Is there something agreed to as to bond or?
Yes, Judge, we have an agreement as to a $10,000 bond, no pretrial. The defendant is not gonna be residing in Broward County, he's be moving back up to Orange, so.
Okay.
And it would be, Your Honor, no victim contact, no firearms, weapons.
Sure.
All right, so Mr. Davila, the court does find probable cause, and I will impose a $10,000 bond and no victim contact, no firearms or weapons, okay?
Thank you. Mr. Davila, your parents are on their way down, they should be here in about an hour. Okay?
Do you understand, sir? I just want to make sure that I hear your response. Please turn the mic on so I can hear Mr. Davila. Sir, you understand everything that has been said here today?
Yes, Your Honor, you said, 10,000 bond?
Okay, and no victim contact, and
No weapons.
and no weapons or firearm. Okay, good luck, sir.
Thank you, Mr. Davila.
All right, Richard Thomas.
He's approaching, Judge.
All right, Mr. Thomas, you're before the court on a KPS for trespassing. The court does find probable cause. What does Mr. Thomas wish to do?
Mr. Thomas wishes to resolve this matter today, Judge.
Okay. Sure.
Offers adjudication, time served. No return to the quick store at 920 East Atlantic Boulevard in Pompano Beach.
Judge, he wishes to resolve that, and he will abide by the recommendation as far as no return.
All right, Mr. Thomas, please raise your right hand. I swear or affirm to tell the truth.
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Thomas, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with your attorney?
No.
You understand, sir, that you have a right to go to trial, but by taking a plea today, you are giving up that right?
Yeah.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
All right, what plea do you wish to enter?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served, and Mr. Thomas, no return to the quick store in Pompano Beach.
Ma'am.
Okay. David Banaszak.
He's approaching, Judge. He's here at Main. Come on up, sir.
All right, Mr. Banaszak, you're before the court for obstruction of highway. It's a panhandling charge. The court does find probable cause.
Judge, and speaking Mr. Banaszak, he did advise me he wanted me to ask the court if the court would consider resolving this matter today.
All right.
Offered be time served, Judge.
All right.
He wishes to accept this please offer, Judge.
All right, Mr. Banaszak, please raise your right hand. You swear or affirm to tell the truth?
I do, Your Honor.
Okay, sir, you can put your hand down. Do you understand everything that's going on here today?
I do, Your Honor.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
I do, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I do, Your Honor.
All right, sir, what plea do you wish to enter?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck. Okay, Daryl Hughes. Hughes, you are before the court for 2 counts of touch or strike battery, and the court does find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Hughes on pretrial release. My understanding, he can't afford to post bond. He gets disability. He gets roughly $812 per month. There's no one that can post his monetary bond, so he's also going to be released on supervision.
Just trying.
Thank you.
I'm just trying to figure out where this happened, because I'm showing that both victims and Mr. Hughes all have show the same residence.
They do. Yeah.
Now, Your Honor, I am a bit concerned about the totality of the circumstances. I'm requesting that the court keep the bond in place. He's had multiple resisting without violence and trespass within the past year and a half. He was arrested last year on a failure to appear.
Judge, I did advise Mr. Hughes that the court is going to be ordering a no contact order, and I did advise him if he violates that, he would be basically arrested again. Now, he does understand then he's going to have to find a separate place to live. It's going to be tough on him because he just paid, I guess, the rent on it. But right now, and that is why he has really no money. All his disability was used towards the rent. So, Judge, at this time, he will be abiding by the court's order as far as no contact. He will be coming back to court, but there's no one that can post his bond, so that's why we're requesting pretrial.
All right, at this time, the court will release Mr. Hughes to pretrial supervision. No victim contact, sir. You're being handed the directions to the pretrial office. As soon as you are released, you must report. Failure to do so, a warrant will be issued for your arrest. Okay?
Judge, one other request. I know he has property there. Can he go back one time with law enforcement to retrieve his property?
One time with law enforcement.
Thank you, Judge.
All right, Harry Deschutes.
He's approaching, Judge.
All right, sir, you are before the court on a misdemeanor capious matter. It's for resisting without violence. The court does find probable cause.
Judge, he's wishing to resolve this matter today.
It's a 2014 capious.
Offers adjudication time served, Judge.
All right.
He wishes to accept the state's offer, Judge.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
And sir, you can put your hand down. Mr. Deschutes, you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And sir, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
Okay, what plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir. Samuel Grell.
Please approach and judge your name.
All right, Mr. Grell, you are before the court. There's two misdemeanor capias. Says on count one is a possession of cannabis and count two is disorderly conduct. This is a capias from March 27th of 2019. The court does find
Judge,
probable cause.
Matter today?
Your Honor, this is at a drug court. He just got transferred in February. It appears, I imagine, it was his wish to go into drug court, so I'm asking that he see Judge Lerner Wren.
All right. He does have court tomorrow, so he'll see Judge Lerner Wren tomorrow. Okay? Dylan Farrell.
Come on up, sir.
All right, Mr. Farrell is before the court. Count one is criminal mischief, and count two is trespassing. And the court does find probable cause.
Judge, I believe this is his first time being arrested. He's 20 years old. Considering these are misdemeanor offenses, I'm asking for a straight RR. If the alternative, no, then I'm asking for the court to leave the bond in place. I'm going to be contacting his family to post his bond.
Judge, I'm going to ask that Mr. Farrell's case be transferred to Judge Lerner Wren.
I think that's the most prudent thing.
Mr. Reading, I spoke about this case this morning. I have no objection. The only request I'm going to make, Your Honor,
Yes.
is an order of no return to Dan Witt Park in Lighthouse Point.
What's the name of the park?
Dan Witt, W-I-T-T, Park.
Okay. Mr. Farrell, do you understand that? No return to Danwood Park?
Yes, ma'am.
I'm gonna leave the bond in place, and I will sign an order transferring to Judge Lerner Wren. Drew Lemke.
Mr. Lemke? I'm sorry, how do you pronounce it? Lemke. Oh, Lemke.
All right, Mr. Lemke, you're before the court. Count one is DUI, alcohol, or drugs. Second offense, counts two and three are DUI with damage to property or person of another, and count four is careless driving. That's not for magistrate. The court does find probable cause.
Judge, he advised me he declined the service of public defender, but I'm going to be contacting his mother as a friend of the court on this. Thank you. Appreciate it.
Okay. Does the state wish to be heard?
Your Honor, I was going to be asking for anything other than the bonds to be kept in place.
Okay. All right, the court does find probable cause and the standard bonds in place will remain, sir. Good luck.
Good luck, sir. I'll call your mom right when I get out of here.
Justin Thomas.
Mr. Thomas is here present, Judge Amin. Come on up, sir. He's approaching, Judge.
All right, Mr. Thomas, this is an ad charge. This is charge number 7 for possession of controlled substance without prescription. And the court does find probable cause.
Judge, at this time, considering he has no bond holds, nothing to add at this time from the defense.
All right, so Mr. Thomas's bond is $1,000. And then Ronald Mobley.
We'll waive formal reading of the charges.
He's approaching, Judge.
All right, the court does find probable cause. Does anyone wish to be heard?
Your Honor, he's got a no bond hold on his other account. I was just going to request a $1,000 bond.
Nothing to add at this time, Judge.
All right, finding probable cause, the court's gonna impose a $2,000 bond. 2,000, yes. Kevin McClendon. Kelvin,
He's approaching, Judge.
okay.
No, that's the
He's
charge.
here.
Grand theft and cheating.
Basically, it was booked as a felony cases, but it's a violation.
I saw what it said, and I said, it's grand theft and cheating. I don't know what he was cheating on.
All right, Mr. McClendon, you are before the court. Count one is a felony violation of probation that has a no bond hold and is not for magistrate. Then count two is a civil writ with a purge amount of $500. And then count three is a traffic KPS for driving while license suspended. And there's a $2,000 bond that's attached to that. The court does find probable cause and will leave the bonds in place, and you will be before your felony judge tomorrow at 8:30. All right, good luck, sir. All right, Roger Joseph,
I've been advised he was reset for the PM.
okay. Drapier Johnson.
He's here present, Judge.
All right, Mr. Johnson, you are before the court. Count one is a possession of drug paraphernalia. Counts two and three are felony capious matters, both with no bond holds and not for magistrate. The court does find probable cause. Your bond on count one is $100, and you do have court tomorrow at 8:30 for your felony matters. Good luck, sir.
Good luck, sir.
Sir. And then Damian De Prospero.
He's approaching, Judge.
Sir, you are before the court. Count one is possession of cocaine. Count two is possession of drug paraphernalia. And count three is violation of pretrial on a misdemeanor matter. That has a no bond hold. It's not for magistrate. The court does find probable cause. And your bond on count one is $1,000. Good luck, sir. All right, on Ray Batista. All right, on that one, if someone has a clearer probable cause affidavit, I cannot read this. It's a handwritten photo, bad photocopy.
Yeah, Your Honor, the problem is, I don't know if I'll be able to print anything out because of the age of the case. We weren't uploading documents into our computer system then. I can tell you it's a file charge. This is a not in custody capias that was issued by the clerk upon filing the information. And from what I can tell, Mr. Batista was transferred here from federal prison. I believe that's where when he's done with this case, he's going back to federal custody. If confinement status can confirm that.
I believe that to be the case.
Okay,
So, Your Honor, and I understand it is difficult to read, but based on what I believe to be a properly issued not in custody capias, that was the grounds for taking Mr. Batista into custody. In light of his other circumstances, I'd be asking the court to find probable cause and keep the $2,500 bond in place.
I'd feel a lot more comfortable if we had something we could read. I know he's going in front of his judge, as I advised him tomorrow, in front of Judge Duffy. And he's really not going anywhere because he's got the federal hold.
And that's really, it really appears to me there's two options. We can reset it tomorrow. I can try to pull the file and see what's in there. Or either way, if he's ROR'd on a finding a no PC, he stops getting game time for his time in Broward when he cannot go anywhere anyways, and he's not getting out of custody.
Well, I don't want to do any of that. What I want to do is the right thing, and I can't do the right thing unless I'm able to read.
Well, no, and that's why I'm asking the court to base it on. There is, and you should have a copy of the capias that was issued by the clerk September 19th of 2007. And that capias is the basis for his arrest.
Good morning, Your Honor. Will you have a chance, may I be able to speak?
I have a capias for failure to appear on a calendar call for a battery charge.
May I say so?
Yes. Okay. All right, Mr. Batista, you wish to say?
Yes, ma'am. During my federal prison sentence, none of this came up. I believe this was,
Okay, I'm gonna stop you, because, I don't want you to talk about your case on the record, okay?
I don't really wish to stop though, Your Honor, because I feel like
All right,
major crimes is the reason why they even brought this case. This case from 2007, like, I mean, it says you guys don't even have the file. That's embarrassing. Like, you guys extradited me. You had all this time to prepare, get me to a courtroom, and you guys don't even have the file. I mean, how does that?
Well, nobody said they did not have the file. We do have the file.
Okay.
And you do have court tomorrow in your felony division, and then on the 9th in your misdemeanor division, so you'll be before two judges, before the end of the week. The court does find probable cause, and your bond, the bonds in place will remain, okay?
Probably the best place to deal with this, Ray, is in front of your division judge instead of here at
Yeah.
magistrate court.
Yeah.
You know, it's not like you're going anyplace to meet right now anyway, so
Right,
hopefully
yeah,
they'll have a lot
that's-
more information for you tomorrow morning.
All right. Well, thank
Okay.
you. I appreciate it.
All right,
Okay.
good luck, man.
All right. Thank you, guys.
Daryl Wilshire?
Mr. Wiltshire, come on up. Come on up, sir. He's approaching, Judge. You share me.
All right, Mr. Wiltshire, you're before the court on a petty theft charge. The court does find probable cause.
Judge, nothing to add at this time.
All right, and Mr. Wiltshire's bond is $750. Ricardo Gonzalez Guerra.
Let's go. Come on up, sir. He's approaching.
Mr. Guerra is before the court. Count 1, which is not for magistrate, is not having child restraint. Count 2 is no current proof of insurance. Count 3 is driving while license suspended without knowledge. That's not for magistrate. And then count 4 is a grand theft. The court does find probable cause.
Judge, first, he doesn't know as far as the not in custody case in count 4. When was the date of incident on that case?
The date of incident on which case?
Count 4, the grand theft.
It's like February 26th of 2019 at Walmart on 5555 West Atlantic Boulevard.
Judge, Mr. Gonzalez did advise me he has a friend that I'm going to be contacting that probably has $100 I can, using the service of bondsman, can post his bond. So on count 4, I'm not asking for the court to take any action, but on count 2, which is the $100 bond, would the court consider an ROR so that his friend can bond him out.
Okay, court will grant ROR on count 2. Jeffrey Lourdes.
On Jeffrey Lourdes, Judge, we have it corrected in reference to count 3.
Count 2 is ROR.
Count 3 was booked as a direct violation of probation, and it is a 94806.
All right, Mr. Laudius, you're before the court. Count 1 is possession with intent to sell, manufacture, or deliver cannabis. Count 2 is driving while license suspended. And count 3 is a felony violation of probation, and the court does find probable cause. You do have court tomorrow at 8:30, and your bond on count 1 is $1,000. Norbert Fodden.
Pardon? He's approaching, Judge.
Mr. Fodden is before the court for grand theft, and the court does find probable cause.
Judge, we're going to be asking for Mr. Fodden to be released on pretrial release. My understanding is he gets disability, he gets about $600 per month, and his rent is approximately $500. He lives in Fort Lauderdale with a friend where he's been living there for 4 years. He's 60 years old. He advised me he's been here his whole entire life, so we're asking for him under supervision.
Your Honor, my concern is from what I can tell, every time Mr. Fodden's been arrested, all of his recent arrests, or most recent arrests, and that is 6 in the last 4 years, every single one was either for a capias for failing to appear, or a violation of probation for violating conditions, or for a court order for a new arrest while he was out on a case. So I'm not comfortable that he would follow pretrial release conditions.
Mr. Romero, Mr. Fodden does have a permanent address?
From what he advised me, he lives in Fort Lauderdale in a duplex. Is that correct?
Yes, 809 Southwest 10th Street.
And you know the address?
809 Southwest 10th Street.
809. He did advise me that he has a permanent address, Judge.
So,
It should be.
what is 3290 Northwest 21st Street in Lauderdale Lakes? What's that?
Oh, that's what I was in one of homes. Them homes where you gotta stay in, they pay rent. It's house of your home.
Okay.
House of your home, yes, ma'am.
And then on the booking report, there's 102 Southwest 9th Street in Hallandale Beach.
Yes, ma'am.
What is that?
That's where I stay, Hallandale Beach, 102 Southwest 10th Street. Oh, that's when I was in a nursing home.
All right, at this time, I don't have confidence that Mr. Fodden has a correct address or will come back to court without posting a bond, so I'm gonna leave the bond at $1,000.
Yes, sir.
Brian Watkins,
He's approaching, Judge.
Mr. Watkins is before the court. Count 1 is battery, second or subsequent offense. Count 2 is trespassing, occupied structure or conveyance. Count 3 is petty theft. Count 4 is trespassing, occupied structure or conveyance. Count 5 is petty theft, and count 6 is trespassing. The court does find probable cause as to all those counts.
Judge, we're going to be requesting that Mr. Watkins be released on pretrial release. Right now, financially, he's not in a position to post his bond. He advised me he's currently looking for work. He lives locally here in Dania Beach, where he's been with a friend for the past 3 years. He doesn't pay rent. His friend is helping him out.
I'm supposed to start work at the Sunoco car wash there, which Sheridan and Federal, though.
When?
I'm supposed to start yesterday.
So, Judge, he did advise me he was looking for work, and I guess he's been successful. He was supposed to start work at a gas station. But from what he advised me, no one can post his bond. That's why he's requesting to be released on pretrial.
Your Honor, I'm going to be requesting a bond increase on count 1 to $2,500. As you can see in these reports, this is a pattern of conduct. Mr. Watkins continues to go to this same Publix, steals from them, and multiple times over a short period of time. And finally, when he ultimately gets confronted the last time by a manager, he commits a battery against the manager. And I would note this is all after he was sentenced. He had a violation of probation before Judge Merrigan. He was arrested January of this year for attempted tampering of physical evidence and possession of drug paraphernalia. He resolved the VOP to 180 days in county jail, credit for time served. He was just released April 26th. He also had a grand theft in 2015. This is just out of Broward, and possession of cocaine, heroin, 2013.
All right, based on the allegations, I do have 2 police reports of 2 separate incidents, one on 5-2 and then one on 5-5. The court finds probable cause and will leave the standard bonds in place.
Your Honor, I just asked for an order of no return to this Publix,
And
please.
then no return to Publix. Please say is the address in,
Yes, ma'am, it is 402 East Dania Beach Boulevard in Dania Beach.
Sir, you are not allowed to go back to that Publix. Do you understand that?
Yeah.
Okay, all right, good luck, sir. Tyrone Dixon.
He's approaching, Judge.
Mr. Dixon, you're before the court. Count 1 is possession of cannabis, 20 grams or less. Count 2 is operating without a valid driver's license. And count 3 is a violation of felony probation. That does have a no bond hold. The court does find probable cause. Count 1, your bond is $100. And as to the violation, you'll be before your division judge tomorrow at 8:30. Good luck, sir. Stacy McGreal.
He's approaching, Judge, here at Main.
Mr. McGreal, you're before the court. Counts 1 and 2, assault on an officer. Count 3 is DUI, third offense, over 10 years. Count 4 is resisting without violence. Count 5 is driving while license suspended. Count 6 is refusing to submit to DUI test. Count 7, careless driving. Count 8, failure to submit, failure to submit insurance. And then count 9 is an expired tag, less than 6 months. And count 10 is failure to display vehicle registration. Counts 7 through 10 are not for magistrate. The court does find probable cause. And I'll hear from the parties as to bond.
Judge, this time I'm not gonna ask you for anything. My understanding is the only phone number he can think of is where he works, so he gave me the phone number of his job. I'm gonna try and contact a coworker to see if they're willing to post his bond.
Your Honor, I have no requests with respect to the bond amount, but considering that this is a third DUI, the allegations surrounding the DUI, I would note he just had a careless driving from 2018 that he just was convicted of April of this year. Multiple DWSs in the past. I'd be requesting pretrial, no alcohol or intoxicants, and random testing in addition to the bond.
What was he convicted of this year?
It was a careless driving, Your Honor, and while, yes, it's a criminal infraction, I think it is relevant for the court to consider any type of driving matter, considering the allegations and his history of DUIs.
All right,
Judge, I think the last DUI, and Mr. McGraw wants me to mention, was over 20 years ago.
And I'm sorry, I didn't realize, also noting this involved a crash.
all right, the court does find probable cause. I am going to include, in addition to the bond, the pretrial with random testing. Standard.
Judge, would you sign a photo order as well?
Sure. Joshua Thigpen,
Mr. Thigpen, bonded, Judge.
okay. Aaron Silberberg. All right, sir, you are before the court. Count 1 is possession of cannabis over 20 grams. And count 2 is improper change of lanes, which is not for magistrate. The court does find probable cause.
Judge, and to me, Mr. Silverberg, this is the first time he says he's been arrested in his life. He's a registered voter. Considering this a cannabis offense, I'm going to be asking if the state has an objection to having Mr. Silverberg released on his own recognizance.
I don't.
All right, so you'll be ROR'd on this arrest. Bazu Jadun Nanan, why, did we have him yesterday?
Yeah, Your Honor, they're gonna, my
And he was
understanding is,
He was Baker acted, yes?
and they're gonna keep resetting him until he's back from his Baker Act.
All right. Okay. Jarvis Petty,
North Broward, Your Honor.
all right, Mr. Petty is before the court. It's on a change of, it's a change of charge.
Yeah, yes, Your Honor, it was filed as an attempt. I reviewed your Honor's original findings. You found PC for attempt.
Of course.
Yes, you did. You set the bond at $100,000. I'm asking that the court set that bond back at $100,000. He's also being held no bond on a separate count that you found proof evident or presumption grade for. And we
Okay.
filed that charge as presented.
All right. So,
He is represented by Joshua Meyer of our office, Judge, and I advise Mr. Petty, I'll let Mr. Meyer know what's going on so we can address that issue.
and he does have court tomorrow as well. So, all right, so Mr. Petty, you were just before the court for technical change. It was something that was already found at the first time you appeared. So as far as the bond is concerned, nothing's going to change or the conditions, but you do have court tomorrow, so you'll be able to speak with your attorney, okay?
Okay.
It was $100,000 with With what?
That,
Or was it just
no victim
100,000?
contact, you already ordered that. You didn't do anything else, Your Honor, considering he had a no bond hold.
Okay, all right. Okay, sir, good luck. Cristobal Ospina.
Oh, maybe that's, yeah.
Is Mr. Ospina another?
He's here present, Judge Amin.
Okay. All right, so Mr. Ospina, you're before the court. Count one is DUI, alcohol, or drugs. Count two is resisting without violence. Counts 3, 4, and 5 are corruption by threat of a public servant. And count 6 is obstruction of traffic, which is not for magistrate. And the court does find probable cause. As to bond,
Yeah, I'm checking to see if there's history. Your Honor, excuse me, Your Honor, I'm going to be requesting bonds, the amount of $2,000 per count on 3, 4, and 5. Based on the totality of the circumstances, I'm also going to be asking for a pretrial release, no drugs or alcohol random testing.
Judge, unfortunately, Mr. Ospina is not going to be able to afford to post a monetary bond. He gets disability. He gets approximately $700 per month. He's been here in South Florida now for about 20 years. He's 25 years old. He lives in Hialeah with his mother. His mother is an Uber driver. Judge, I'm going to be also asking for a photo order. But right now, from what he advised me, he doesn't think he can come up with anything, so that's why we're asking for Mr. Ospina to be released on pretrial release.
all right, reading this probable cause affidavit, the court does believe that it is full of all kinds of allegations of threat from Mr. Ospina, and it just goes on and on. So the court does find probable cause and does have concern for not only the safety of the community, but for Mr. Ospina as well. I am going to impose $2,000 on each count and of counts 3, 4, and 5. And that's going to also include level 2 GPS.
Did you say phone or photo order, Mr. Romero?
Photo order.
And no alcohol or intoxicants. Okay?
Your Honor, is that going to be with testing?
Yes. All right, and then do we have Willie Richardson?
Yep.
North Broward, do we have Willie Richardson?
He's a medical reset, Your Honor.
Okay, thank you.
You're welcome.
All right, we'll reset Mr. Richardson. Thank you, everyone.
Thank you, Judge.